This is how MOFA 1963 used to work. The duty of the builder to disclose various documents, plans, etc. was there. But if he doesn't do it, what happens? Will a policeman go after him? No. Will government agency go after him? No. Government agencies say we will give permissions. Our job is to give permissions. Our job is not to make him show those permissions to you. Various permissions are required from various departments, from urban development, from BMC, from revenue department, depending on the status of the land, depending on the status of the property. You will have various permissions that are required. But what clearly happened was the duty to disclose was there, but the enforcement and delivery mechanisms were missing. They just were not there. So, if you have to make that happen, obviously compliance didn't happen, and we all know compliance didn't happen. And over the span of these decades, builders have a very bad name. Everybody says chore hai. Kya karne ka? We accept it. Now, what do you do if you are a flat owner and you want to make him comply? First of all, unless you bought the flat, you can't do anything. If you bought the flat and you find that there are violations, then you have some kind of locus standi in the matter. Then you will file RTIs, you will go to BMC, they will evade you. Long story short, it's a headache. You will get the information, but after a lot of banging your head on the wall. What happens after that? After that, you have to get him punished under MOFA. So you will have to go to a lawyer, you will have to engage a lawyer, you will have to file a plaint against him. You have to go to civil court, you have to go to small causes court. This is the way it works. How many people can do that? And for this reason, compliance with MOFA 1963 was completely missing, although it specified imprisonment as a punishment for builders who did not comply. I am giving you a bird's eye view. Now let us take a look at the new act, Maharashtra Housing Act. Let us just call it Maharashtra Housing Act or Maharashtra Regulatory Act. Maharashtra Housing Act, I think this slide was made at the time of the bill, but the same thing has turned into the act, so let's go with it. It casts a duty on the builder, same as MOFA, almost identical, in fact with more detailing. It casts duty on builder to disclose various documents, plans, etc. Then what does it do? It creates a mechanism, a housing regulatory authority. Now once you have an authority, that authority has the full-time job of following up whether compliance is done or not. Suo moto, without you having to go and move any government agency, it has the full-time job of doing that. There are in fact mandates that a builder cannot proceed with selling the flat until he has declared it to the Housing Regulatory Authority, and unless Housing Regulatory Authority has put it up on the website, or rather he uploads it on the website to with a password given by Housing Regulatory Authority. So the first step, says Housing Regulatory Authority, is you declare it to the public, put it on the website. This is where all the problem was in the earlier one. Now, regulatory authority cannot be everywhere, so they are empowered to appoint competent authorities in regions, in various places, in various districts. That competent authority is the person to whom the builder has to submit the documents, right? Then, suppose there is a dispute. Regulatory authority says something, or flat owner says something, builder says something else, etc., etc. Does the matter go straight to court? No. There is an appellate authority. So the appellate authority, from the regulatory authority, the matter will be escalated to appellate authority. From the regulatory authority, the matter is delegated for local work to a person specifically designated as competent authority. Just as you have in the corporation department, you have district registrar and so on. Same way here you will have, about the same rank, you will have competent authority. That competent authority will ensure grassroots level connection, which was missing with MOFA, and acts on behalf of housing regulatory authority, and if matters go bad, escalates to appellate authority. The result is compliance and service delivery as per agreement, as per rules, as per laws. Further, let me share with you one more thing. An act, a law, a legislation, often needs to be further detailed, further articulated, further fleshed out according to local conditions, according to local laws in each state, sometimes even at smaller units. You know, rural areas one thing, urban areas another thing, metros one thing. So for that, there are rule-making powers that have been given to the Housing Regulatory Authority, Maharashtra Regulatory Authority. The rule-making powers will ensure that they are able to stop any leakages as and where they happen within themselves. They don't have to refer back to legislature. Okay. Now let me take you to the overview. Basically, I'm telling you the same thing that happened earlier. MOFA 1963, it cast the duty on the builder, but there were no authorities to implement. So the aggrieved person should follow up through RTI, gather evidence, go to small causes court, civil court, etc., etc. There were no administrative remedies, which means you could not go and complain to a government authority. The government authority had no power to force him to comply. No rule-making body existed, so there were no rules. No timelines for compliance, most crucial. And if there are no timelines, things can go on and on, roll over for years. And it said there would be imprisonment if the builder was found guilty. Now, imprisonment, because of the serious nature of imprisonment, it means that rather than just declaring a builder wrong, you have to declare a builder guilty in a court, which is a hard battle. I mean, you know that even serial murderers don't get hanging for decades. That is how our Indian system is. Now, as opposed to that, what Maharashtra Housing Act has done is, it said, okay, no imprisonment because imprisonment gets very complicated. Let us do penalties. But penalties can go up to 1 crore rupees. And there are various heads of penalties. So if you get penalty on various counts, maybe cumulatively it may be much more than 1 crore also. Here, the aggrieved person does not have to search for a lawyer. He has to go to the the competent authority. He has to follow up with regulator. He has to follow up with appellate. Now, this is a mechanism that is going to government, going to competent authority, etc., is a mechanism that a lot of activists are quite familiar with, and therefore would be happy to familiarize you with them. So instead of going to lawyers, right, you can phone an activist like myself. There are many like myself, many who are even better informed of ground level realities, and we advise you. Often we advise you free of, most of the time, we advise you free of charge over the phone, give you a lot of hand-holding over for hours. We help you by email to frame and construct your complaint. We help you to represent, okay, or you can represent yourself. You can very well represent yourself. It's like going to a government office. So, rather than having to go to court and battle it out with lawyers, you are going to go to a government office which is dedicated to compliance by builders, and timelines are provided, you can show he crossed the 7 days threshold, he crossed the 60 days threshold, he crossed the 90 days threshold. There are all kind of thresholds that have been defined. For you also, you are supposed to complain within a certain period of time. He is supposed to comply within a certain period of time. Replies are supposed to be given within a certain period of time. Matter has to be resolved by the appellate authority again within a certain period of time, 90 days. There is a threshold. If that threshold is crossed, you have to give a reason why that 90 days was crossed. So, no imprisonment but heavy cash penalties for violations. Let's just take a very brief overview in case I have missed out anything, which I would have because it's a large act, and I'm giving you a very quick explanation. What are the functions of the regulatory authority? I'm going to summarize it in three things. There is adjudication, there is regulatory functions and rule making, and there is interaction with the developer. Directly interacting with the developer to ensure compliance. You see, developer like you and me is a human being. Unless and until someone frequently reminds him to stay on a certain track, like you and me, he loses track. And he runs an office. That office loses track. So, let me start with the developer. The developer has to now register with this regulatory authority, and the regulatory authority will aggregate all the permissions on its website, authenticated, first copy, scans, okay, on their website. Secondly, that website is being maintained, and therefore all permissions of all builders, regardless of whether he is your builder or not, will be available on the website. Therefore, not only for the aggrieved person, the flat owner, but even for an RTI activist or a whistleblower who is simply interested in compliance for the sake of compliance. And please note, there are people like that who are working for the sake of compliance. They don't want to blackmail the builder, they don't want to get money from him. Okay, RTI activist community thoda badnaam hai isme. But that is not the fact everywhere. There are of course people who would want to make money, but by and large people want that information to be out there in the public domain. So that is going to happen. Thirdly, compliance of obligations. The authority, the competent authority and the housing regulatory authority will interact with the builder. The office will interact with the builder and ensure compliance of obligations. And very important, see, today if a builder defaults, he is able to default in one place, but he is advertising in another place. He may be almost a criminal, okay, he may be a rogue in three places, but the word doesn't spread because nobody wants to talk against a builder, and media will not carry stories against a builder. In the fourth place, he is portraying that this is a super success, and he is fooling investors, he is fooling flat buyers, he is fooling everybody. What happens now is, there is a record keeping mechanism. So, it will enter the names of defaulter web developers on the website. So, in a way, it creates a rogues gallery. The rogues gallery is where you have photographs of defaulters, rogues. Okay. So now you have a clear thing for the public. They will not be fooled by tall claims because they just have to quickly go through the rogues gallery to know, oh, this builder has, okay, here, in this there's a default, in this there's a default, okay, I know I have to be careful. It's very simple. Okay, so this is vis-a-vis interactions with builder. Now secondly, adjudication. When dispute arises between the allottee, the flat allottee, or the society. The disputes with society arises when there have been defaults concerning, for instance, common amenities. Okay? Quality of common amenities were not as per plan, were not as per agreement, and so on and so forth. Conveyance was not given. Conveyance is supposed to have been given under the MOFA Act. But how many buildings actually get conveyance? We know the story. Why? Because of this. Now, adjudication will ensure that conveyance gets given in a timely way. Title passes in a timely way. The builder does not start building in the first place before his title is in place, and so on and so forth. So, settle disputes among the allottee and society and between allottee and promoters and determine penalties. Regulatory and rule making. As I said earlier, rule making, articulating, passing directions, passing circulars from time to time. This is a necessary part of ensuring that the law works. You have to keep changing things from time to time in order to ensure that it works, because the environment that we live in is evolving. We are not in a static environment. So you have to change the laws. You have to change the rules, not the laws. You have to change the rules frequently. You have to pass directions. You have to ensure that circulars are given. You have to ensure deadlines are given. You have to delegate powers. Sometimes you have to take away powers. All these kinds of functions are there now, will be done under the regulatory authority. Ensure compliance of directions. Make recommendations to government. Now, currently, if some changes are desirable, who is to make the recommendation? You and I. People like us, public spirited citizens. Other than that, nobody. And government will not take us very seriously for obvious reasons. Because they say, "Ha, tum hai kaun bhai?" Okay, then you have to form a big association of flat owners and create a locus standi for yourself, create credibility for yourself, or say that you are a big expert like Ramesh Prabhu. Then you will get some consideration from the government. Even then it's an uphill task. Here, there is a legitimate channel for recommending to the government. You recommend if you want. You can make all kind of representations to the regulatory authority, and they will advise the government, right? And making inquiries again with the follow-up with the government also is a thing that requires a mechanism. So you have a mechanism here. Okay. So I have summarized for you in these 5 slides the Maharashtra Housing Act.